Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us, coming to you from our fantastic Central Washington location here in Cle Elum. It's been a while since I got to get over here. We're going to talk about red flag laws again. Specifically, we're going to talk about red flag laws in New York. Now, as you know, the governor and the state government has been very braggadocious about how much they've been utilizing their red flag laws. In fact, there's about a quadrupling of numbers from just 2 years ago in the execution of red flag laws in New York. But there has been a challenge to red flag laws, and there is now a published opinion. We want to kind of geek out on that because we know that the future of red flag laws is up for debate. We know that there's going to be a lot of litigation, and we know with the Bruen opinion, there's going to have to be some serious soul searching about the legitimacy of red flag laws. Today, we're going to teach you a way that we believe those who support civilian disarmament are actually going to uphold red flag laws under the Bruen opinion. So today, let's slow it all down, and let's geek out a little bit, and let's talk about when New York's red flag laws meet the Bruen opinion. Okay, so the case we're talking about today is the case of Gagno v. DS. It is filed in the Supreme Court of Dutchess County, New York. Now, Mr. DS had a red flag, extreme risk protection order, whatever the hell they're calling it in New York, executed upon him. And these are the only facts that I know, the petition alleged the following. The respondent has engaged in, exhibited, or committed the following behaviors. Check all that apply. 1. A threat or act of violence or use of physical force directed towards self, the petitioner, or another person. 2. A pending charge or conviction for an offense involving the use of a weapon. And 3. The reckless use, display, or brandishing of a firearm, rifle, or shotgun. Now, the red flag order was obviously granted by the trial court level. Mr. DS actually then ended up appealing to the Superior Court of Dutchess County. The court there has issued an opinion, and so this is where I want to kind of slow it down here for a second and get you all to understand. Okay, so now as you guys have all been geeking out on the channel for a while, you know that anytime we're challenging the constitutionality of any gun regulation, we're going to apply the Bruen test, which means, number one, is the activity that's at subject here actually covered by the plain text of the Second Amendment? Now, one would think, you know, the ability to possess a firearm and being disarmed without due process of the law might be one of those things, but we'll circle back on that. And then number two, if the plain text of the Second Amendment does cover the activity, is there a historical analog that the government can point to that shows that we as a society have accepted this sort of restriction in the past? Now, of course, if the plain text of the Second Amendment does cover the activity, then it would be government's job to come up with a historical analog to justify and prove that we as a society have accepted these sorts of restrictions since the formation of our Constitution. The government and the court here obviously does not want to go to that second step because there is absolutely no historical precedent to justify disarming an individual without due process of the law based merely on an allegation. So the only out here is to find that the plain text of the Second Amendment does not cover this activity. How could you possibly do that? Well, you could find a couple of words in the Bruen opinion, cite it ad nauseum, and then find that this activity is actually not covered by the Second Amendment. Let me show you how they do that, because what the court did here is they went back to the Bruen opinion, and they went back to the Heller opinion, and they pulled 11 separate quotes out, and I'll just read the first few so you understand what we're talking about here, but you'll see where the court went. In District of Columbia v. Heller and McDonald v. Chicago, we recognize that the Second and 14th Amendments protect the right of an ordinary, law-abiding citizen to possess a handgun in the home for self-defense. In this case, petitioners and respondents agree that ordinary, law-abiding citizens have a similar right to carry handguns publicly for their self-defense, citing de Bruen at page 8. Check this one out. Nor is there any such historical tradition of limiting public carry only to those law-abiding citizens who demonstrate a special need for self-defense, citing de Bruen at page 38. Or this one. As set forth in the pleadings below, petitioners Brandon Cook and Robert Nash are law-abiding adult citizens of Rensselaer County, New York. And there are quote after quote after quote. And so where the court is basically coming down is, listen, the Second Amendment only protects law-abiding ordinary citizens. Now, what that term means, God only knows, but for the respondent in this case, Mr. DS, I think we know what that answer is going to be. And so ultimately, where the court hangs its hat is here. Respondents seek to have the court ignore this language in Bruen. First, he argues the language is dicta. Secondly, he argues that the language is vague. Both arguments fail. First, to call some of the language of Bruen dicta is to ignore the mission imposed by the Supreme Court in Bruen to discern the limitations that have been and will be allowed on the Second Amendment. As to the vagueness argument, the U.S. Supreme Court has left open for some future time what the law-abiding and responsible terms will actually mean. Void for vagueness is a concept applied to statutory text, not U.S. Supreme Court precedent. And with that, and expanding upon that language, the court came to the conclusion, in sum, there is simply no reading of the Bruen decision that can be understood to prevent a state from enacting legislation to keep firearms out of the hands of those who are dangerous. In fact, the language of Bruen appears to stand for the opposite. Now, of course, without the Second Amendment even applying to DS's activity, because he is neither a law-abiding nor responsible nor ordinary citizen, according to the court, how does the court deal with the obvious due process deficiencies that come with red flag laws? They do so as follows. What respondent argues for is a procedural due process superior to those for other rights. The Second Amendment is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees that we have held to be incorporated into the Due Process Clause. Neither is it a superior right. Article 63A provides sufficient process at the beginning of the ERPO proceedings in the form of the necessity of probable cause demonstrated before a neutral magistrate for a short curtailment of Second Amendment rights in the form of a temporary extreme risk protection order. Further, the process for an ERPO determination at a hearing, that being proof by clear and convincing evidence of dangerousness, provides sufficient safeguards for the protection of the respondent's Second Amendment rights. And then ultimately the court upheld the extreme risk protection order that was issued against respondent DS. Now, we know that this is going to be the first shot in what's going to be a long, long battle as it relates to the constitutionality of red flag laws, both in substance and in the procedural application. This is likely to be a process of thought, a rule of law that will be expanded throughout all of the jurisdictions that support civilian disarmament legislation. Okay, the case once again is Gagno v. DS. We will link up the opinion down below so that you can geek out on it for yourself. Now, in the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information, it's also down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.